So we've talked a lot about the new laws in the Bharatiya Nagarik Suraksha Sanhita 2023, especially around punishment under Chapter 27. But do you know how these punishments are decided by the courts? Because justice is not only about declaring someone guilty, it's also about deciding a fair and appropriate punishment, and the BNSS brings in some important changes here. Well, today let's try to understand how punishments are awarded under the BNSS, and for that we need to answer a very basic question. What is sentencing? Well, sentencing is the process where, after a person is convicted, the court decides on four things: what punishment they should get, how long the sentence will be, whether the sentence should be strict or lenient, and whether any alternatives to jail can be considered. Now the BNSS has made some important changes here, and it emphasizes three things. 1. The need to reform and rehabilitate offenders. 2. The need to reduce overcrowding in jails. And 3. The need to protect the victims and society. So punishments now aim to balance justice, deterrence, and reform. Let's look at how this works in practice. First, the BNSS talks about a pre-sentencing hearing under Section 400. Now this is mandatory after conviction, before announcing the punishment. The court must hold a hearing. During this, the court will talk to the accused and hear about their personal background, family situation, age, health, past behavior, etc. This is important because every individual is different and so is their crime. So the court needs to understand who the person is before deciding on a punishment. The court will also consider the impact on the victim and then decide on an appropriate sentence. Next, the BNSS talks about various factors that the court must consider while sentencing. And these are very important guidelines. The court will consider 6 things. 1. The nature of the offense. What was the crime? Was it violent? Did it cause financial or emotional harm? 2. The degree of harm to the victim. 3. Whether it was a first-time offense. 4. Whether the accused cooperated with the investigation or not. 5. Any past criminal record. So these guidelines help ensure that the punishment is fair and not based on any biases, and it is not too extreme or lenient. Then the BNSS talks about different types of punishment that can be awarded by the court, and this is again quite comprehensive. The BNSS allows the following punishments, which are similar to what was provided under the CrPC: imprisonment, which can be simple or rigorous. That means some hard work along with the jail term. There's also fine or penalty. Then there's probation, which means releasing the accused with some conditions and supervision. In some minor cases, the court can even award community service instead of jail. Also, the court can ask the accused to pay compensation to the victim. And lastly, there's the death penalty. But this is only in the rarest of rare cases as per the BNSS. So judges now have more structured options and flexibility when it comes to awarding punishment. Another important thing that the BNSS talks about is probation and non-custodial sentences. The idea here is that for first-time offenders or those charged with minor offenses, the court can choose not to send them to jail. Instead, the court can give them a warning, ask them to attend counseling sessions, or even do some community service. Plus, if the accused completes these non-jail sentences successfully, they won't even get a criminal record. This is good because it encourages people to not commit crimes in the first place, and it also helps reduce repeat offenses. Plus, it helps avoid overcrowding in jails and the associated problems like lack of resources and spread of diseases. Then the BNSS specifically talks about compensating victims for their losses. Under Section 401, the court can order the convicted person to pay money to the victim. This is meant to compensate for injury or loss suffered by the victim. It can also be for the cost of medical treatment or rehabilitation. And the BNSS says that women, children, and elderly victims should be given priority. So punishment isn't just about putting someone in jail. It's also about restoring the victim to the best extent possible. Next, the BNSS talks about consecutive and concurrent sentences. What's the difference? Let's say someone is convicted of multiple offenses. A concurrent sentence means that the punishments will run together, meaning the person will serve the shortest amount of time. A consecutive sentence means that the punishments will be one after another, meaning the person will serve the longest amount of time. So, under the BNSS, the judge gets to decide how these sentences will be served. This gives the courts more control over the punishment, and it lets them be more fair and flexible based on the severity of the crimes and the intention of the offender. Lastly, the BNSS allows both the accused and the state to appeal against the sentence. This is important because right now only the accused can appeal against the sentence. The state cannot. This means that if the state feels that the sentence is too lenient, they cannot appeal for a harsher sentence. But under the BNSS, both sides can challenge the sentence, which ensures that justice is served in both directions. No one wants excessively harsh punishments, but no one wants leniency in serious crimes either. To conclude, the BNSS makes sentencing more balanced, transparent, and just. It focuses on 3 important things. 1. The need to reform and rehabilitate offenders. 2. The need to protect the victims. And 3. The need to ensure fair punishment. With these changes, India's justice system is moving towards being more modern and focused on real justice. We at Man Up Legal hope that you found this video helpful. We'll continue to make more videos on the new laws and how they affect you. Thanks for watching.